Good morning, everyone. Welcome to another forms class. Let me turn the volume down on that.
Yeah, maybe give it to him.
All right, so kick
You're going
things
to the
off
gym
today.
today.
I am actually going to be going over a few different things this time first. Normally, we just jump straight to the forms manuals, dive in and start going over, but since the manuals on these forms are a little bit shorter, we're gonna look at a few other things to kind of like tie it all together. First, who remembers what's our first form? 22 RA. What form is that? You guys remember?
Attorney review.
Yes. Attorney review contingency. Absolutely. So let me share my screen. And jump to here. You guys can all see that. So first things first, I had ChatGPT pull up Washington State's top 10 list of real estate lawsuits that has shaped the industry.
Interesting.
So
Hmm.
I figured this would be a good one to kind of review and look at. So Washington State has witnessed several pivotal real estate lawsuits that have significantly influenced the industry. Here are 10 notable cases. So in real estate brokerage antitrust litigation in 1980, this case addressed alleged unfair trade practice
I'm gonna ask him.
and restraint of trade by 12 real estate companies focusing on list-back agreements where brokers required builders to grant them exclusive rights to sell development houses. The Washington Supreme Court examined these practices under the Consumer Protection Act. So does this still happen today? What do you guys do? For those of you, for listbacks agreement, yeah, with arrangements with
Yeah.
builders.
It does,
It sure does.
yeah.
Isn't that crazy? So let me take a peek at this so we can jump straight to the site from where this one was referenced from. So let's see. Attorney General alleged that the brokers engaged in illegal tying arrangements, conspiracies in restraint of trade, and unfair methods of competition in the sale of development lots and development houses. The complaint stated that the brokers required the builders who wished to purchase development lots to grant to selling broker an exclusive right to sell the development houses to be constructed on the development lots. This arrangement is called a list back. It is alleged brokers use economic power, refusals to deal, disparagement, and threats of disparagement to coerce builders to enter into the list-back arrangements. The state's amended complaint requested an injunction restitution for injured parties, civil penalties, costs, and attorney's fees. So it names even like, here's the cases and everything. John L. Scott was even in this one. This is still, it still happens today. But realistically, it's more or less, you will see it's kind of just a handshake. I have not seen a contract come back, at least in quite some time, that literally states, you must use me to list these when you build them in the future in order for me to sell you the lots. It still happens. It still 100% happens. Alex, you deal with you have people you sell lots to?
Yeah, actually, I have a meeting with Rush Residential on a 6.6 acre lot that I want to get the list back.
Of course you do.
On Monday, I have that meeting.
Right. But this is the thing is that, you know, it passed, this was back in 1980, I think it said, right? Yeah, December 31st, 1980. And it basically sued the real estate brokerage. It's all part of antitrust law for that one. you can't do a tie-in like it says. It just basically. You probably would, it would probably be considered these days probably unenforceable. I'm thinking that. A builder or anyone you sell to, if you had language like that in it, they would just be like, yeah, whatever, I could easily get out of this. It's antitrust. So there's our first one. So that definitely reshaped things. All right, let's look at the second one. Tomlinson versus Clark in 92. This case clarified the application of a bona fide purchaser doctrine to real estate contracts. The Washington Supreme Court ruled that real estate contract purchasers are within the scope of the bona fide purchaser doctrine, especially following legislative amendments to the recording statute. So let's look at this case. This was February 27th, 1992. Here's the facts of the case. Actually, Cal, I'll have you read this one.
This dispute is over a small parcel of lakefront property in Snohomish County. Sole issue is whether a purchaser who is buying land under a real estate contract can be a 500 bona fide purchaser and as a consequence have an interest in the land that is superior to a prior unrecorded interest of another purchaser who also is buying the land under a real estate contract.
Okay, so you guys understand what that is?
No.
This still happens today. That sounds like a wholesaler. So he's doing a real estate contract with the seller.
Okay.
And then they're selling he's selling the contract immediately to someone else for more money. I'll bet you.
What does it mean, have an interest in the land that's superior to another person?
That interest is higher than the seller still has, basically. So they were probably putting some teeth in their contract that gave them the rights to do stuff that only an owner would be able to have rights to do. That's the way it sounds. Well, let's dive into the
Doesn't that kind of
case.
make it security sales?
All right, so 1979, Gail and Annie Witzel agreed to buy a parcel of land from Tomlinson. The property consisted of land lying somewhat north of Vernon Road. I've heard of that, actually, as well as 50 linear feet of lakefront property south of Vernon Road. The 50-foot strip of lakefront property was to adjoin 50 feet of similar property already owned by the Witzels. The property was sold to the Witzels under a real estate contract, included a legal description of both the land, both north and south of Vernon Road. Unfortunately, the legal description was incorrect. Rather than describe the 50-foot strip the Witzels intended to buy, the contract described all of the shoreline property owned by Tomlinson, 125-foot strip of lakefront. Neither the Witzels nor Tomlinson became aware of this mistake until 1986.
Oh, wow.
The real estate contract between Tomlinson and the Witzels was executed March 23rd, 1979. The Witzels intentionally did not record the contract at that time. That's always a problem.
Mhm.
We still see issues of that today. The contract was eventually recorded on October 19th, 1982. So 501, 9 months after selling the land to the Witzels, Tomlinson sold a different parcel of land just north of Vernon Road and the lakefront property to David and Cynthia Clark. The Clarks intended to purchase the entire 125-foot strip of lakefront property owned by Tomlinson, as well as the parcel of land just north of the road. Like the property sold to the Witzels, this property was sold under a real estate contract. The land is legally described in Tomlinson Clark contract, included the entire strip of lakefront property. The identical lakefront land sold to the Witzels under their contract with Tomlinson.
This means it's being sold twice.
Yeah. At the time the Clarks purchased the property, they were not aware of the Witzels' purchase of the land and were not aware that the Witzels claimed an interest in the 50-foot strip of lakefront. The trial court's finding of fact with respect to the Clark's lack of knowledge was not challenged by the Whitsells and thus is a variety on appeal. The contract between Tomlinson and Clark was executed December 26, 1979, and was recorded about 5 weeks later on February 7, 1980. In 1986, the parties discovered that both real estate contracts conveyed an interest in the same 125-foot strip of lakefront property.
Oops.
The Lakesells and Tomlinson sued the Clarks, asking the Superior Court that a mutual mistake justified reformation of the contract between Tomlinson and the Clarks. Clarks responded by asking the court for an order establishing them as the owners of the lakefront property, or alternatively for damages. The trial court found that the Clarks were unaware of the Whitsells' interest in the lakefront property until 1986. It also found that neither the Clarks nor the Whitsells had fully performed under the contracts, and therefore neither had legal title to the property. The trial judge then ruled that because legal title had not passed to the Clarks before 502, they learned of the Whitsells' interest in the property. The Clarks could not be bona fide purchasers for value. Okay, so it wasn't a fact of a person getting the contract, selling it. It was the fact that they didn't record it. They didn't know the mistake was even there for many, for years later. And they actually sold the property twice because they didn't realize that legal was incorrect. And the way that they wrote the deal, they basically sold the same lakefront property 2 times. And what's worse is that it wasn't even done right. And so the judge is basically saying neither one of them have a right to it. So that's a huge mess, big mistakes. Basically when you're dealing with real estate contracts, you've got to make sure that they get recorded, right? That run it through title. Nowadays we pull title early, we verify ownership, they verify the legal description is accurate to the parcels and to the recording, and there's been no boundary line adjustments or anything else like recorded to where they've sold it, so that when they go and sell it, they're buying exactly what they think they're getting.
I wonder if the Whitsells sued their attorney. I mean, come on.
Yeah, I mean, whoever handled that, I'm sure that they went after them. All right, let's look at the third one.
Can any of this have an effect on the broker? I mean.
What's the saying in real estate? Anyone can sue anyone, anywhere, at any time for anything. It doesn't matter. You could do every single thing perfectly right down to the T, and you can still be sued. In my 25 years, I've had one dealing where someone tried to sue me. And long story short, I had a friend, his mother and father-in-law wanted to sell their home and buy vacant property and build. I listed their home. These are the same people I've told this story about when I talk about, hey, if you're, decide to take anything with you, you got to mark it. We got to have it in the contract. So if you don't want to include it in the sale, we need to have that done. I prefer you remove it already, so it's not an issue. And then you're not going to worry about someone like wanting the custom chandelier. That's a family heirloom. So you want to get those things out of the property before you list it on the market, so you're not dealing with it. So I've had that conversation with them about this. This is the same people literally that killed a cash deal from people coming from Hawaii that gave them everything, all the terms they wanted, even delayed possession, and they waived inspection. They were driving by to show their family friends, like, yeah, this is the home we're buying here. We're going to be like 2 blocks over from you, and the sellers are digging up their plants in the front yard and trees, and they're like, what are they doing? What the hell's going on? So then when the buyer broker called me and said, Eric, what the hell's happening? My buyers drove by the house, show their family and friends, and your sellers are digging up a bunch of plants. What are they doing? And I have no idea. I'll call them and find out. So call them and they're like, oh, we're just digging up the bulbs, you know, we're gonna take something. I'm like, what are you doing? You can't do that. I go, you just had the buyers come by. Now they're freaked out. And sure enough, they just walked. They said, we're out. They walked on the last day of the information verification period. They're like, nope, the property's not the same. We're out. And they're like, they can't do this. I'm like, yeah, they can.
You can-
I remember the conversation we had about this. You can't take stuff. They're like, oh, we can put them back.
I had
They're just not gonna trust you.
seller in Mill Creek come back in the middle of the night and dig up and take all the rose bushes from the front.
Oh my gosh. Oh my
And
goodness.
this is before I was a real estate agent, and so, I mean, we didn't do anything about it, we were pretty upset about it, but, I mean, it wasn't even like right after the sale closed, it was months after the sale closed.
Yeah. Oh my goodness.
Yeah, so we didn't even know we had recourse.
Wow. Yeah, that's bad. So same people. We got another buyer because they walked, finally got another buyer, wasn't as good at terms. But they were, you know, basically, yep, we're gonna close. So then I found them vacant land. And they were like, so I'm like, are you gonna use finance? Are you using all cash? They're like, oh no, we're gonna use all cash from the sale from our home. I'm like, okay, so. Well, I wrote it up that way, all cash, you know, closing. And this is like back in 2005. If anybody has been around in the market, then that was like a time where it was getting really hot for not only like the whole market, but just vacant land builders were starting to just go gangbusters. So land was like getting harder and harder to come by. So got the land tied up. They approved their feasibility study. And we are in the week of closing. And I get a call from escrow. They're like, hey, Eric, I just talked to the buyers and they're saying that we need an extension because the appraiser needs more time to appraise the land. I'm like, what? Appraiser? I go, oh, it must, because it's probably a mistake. We're all cash, you know, that's not us. And they go, no, Eric, we talked to the buyers. I'm like, what? So I call them. I'm like, hey, I just got a call from escrow. What's going on? We've approved our feasibility study. We have a closing date. I'm like, you got a good deal on this piece of property. If you don't close, I don't see them continuing selling to you. They're gonna sell to someone else for more money. And they basically, oh, Eric, it'll be fine. Yeah, we just need an extension. Can you please ask for them? So I sent them in writing. I go, we're basically reiterating the entire timeline of what happened. And I said, as I previously stated, I do not believe we're going to get an extension because you can't just change your finance. You can't switch to financing and towards the end of the deal. There's just no way. I don't see them approving this, but I will send the 22Y, modification of closing date anyway to try to get, them to extend. And what do you guys think happened?
Oh, they said, kiss off.
They laughed. They're going, thank God you guys didn't close because we just got like 50,000 more. Come to find out, seller buyers, they used a bunch of their funds that he wanted to start his own excavation company. So he bought a bunch of big equipment, spent a ton of the money. So I'm like, who does that? Like, okay. And then they tried to sue me and I just like, okay, here's all my documentation. So they can't, it never went anywhere. And John Scott's attorney, when we forwarded all the documentation I had, they're just like, Eric, don't worry, you're fine. You clearly told them what was gonna happen.
And that's the key. Everything has to be in writing.
Documentation.
Everything. And save and put in the file.
Yep. All right, so number 3, Washington State Department of Licensing versus Cougar Den Inc. 2019. So this is a newer case. The U.S. Supreme Court held that the Yakama Nation Treaty of 1855 preempts state law preventing Washington from taxing fuel purchased by a tribal corporation for sale to tribal members. This decision underscored the impact of historical treaties on the modern real estate commerce. That one's very rare, that's obviously something a pretty rare one, but still showing that, they're still protected. Number four, Attorney General's lawsuit against Real Estate Investment Network in 2019 also. The Washington Attorney General sued Real Estate Investment Network for scamming foreclosed homeowners out of surplus funds. The lawsuit resulted in the company dissolving and paying up to $85 million. I see another comma there. Highlighting the state's commitment to protecting vulnerable homeowners. So this came from the Washington Attorney General, which there is a new thing coming this next year in 2026 that is also came from Washington State Attorney General's office that's protecting homeowners against wholesalers.
Mhm.
So this is coming. It'll be 2026. I think is the date, the start date that anyone who goes directly to a homeowner and that they try to buy off market, that they will be required to have an appraisal
Oh, that's good.
issued to the homeowner.
Like that
Oh,
big
interesting.
organization, Mom's House, that goes in,
Yep,
does that for seniors.
yep. This is something that has been needed for a long time. There's a bunch of, wholesalers that, they write these contracts and they find grandma who has her house in downtown Kirkland and she's like, they're like, how much money do you want? And she's like, well, we bought it for, 90,000 back in the 1960s. Which it's worth about, 1.4, just the land itself, because you got views of the water, and you'll be able to build all these townhomes there. And they're like, yeah, I think we could probably do something, good for you, probably about 600,000. Is that good? She's like, oh, that's great. That's great. Like, tell you what, we're gonna handle everything. You don't have to put it on the market. No, nobody has to come tromping through your house. We'll even give you a delayed possession, let you stay in the home for like a year for free. Doesn't that sound wonderful? And she's like, yes, that's perfect. That'll give me time to move. Then they sign this contract and then they immediately they do it and or assigns and they sell it to someone else for $1 million. Right? So now they got immediately $400,000 cash for just the contract sale, and they've done nothing. That is equity skimming. That is fraud. That is the kind of stuff that if brokers are licensed and they're doing it, they should not be licensed. They should be out of this industry because realistically, why we do this is to help people. You're being compensated the highest dollar amount in any industry. And if you don't think that's true, what happened in the past few years with the antitrust lawsuits? They think brokers make too much money.
We don't make as much as lawyers.
Yeah, yeah, exactly.
When did you say that's starting?
That's new law, Vanessa, starts in 2026. It gets implemented. It's already passed.
That matters a lot about what I'm gonna be doing, because there are a lot of seniors who have like not homes in not disrepair and everything.
Yeah,
So I have contacts with a few buyers that will buy those. So that really,
yeah, you really got to know that that's going to be implementing. I think that's something that, you could be talking to. I mean, realistically, that would be a great thing for you. You could put on your own little mini seminar to say, hey, there's a new law that's coming. This is to protect Washington homeowners. And this is what it is. This is, yeah. I forget the House bill number. It's a newer one, but anyway, you can look it up.
So it was $85,000. So they were willing to go after even a smaller fish.
Okay, so yeah, this one, AG Suits puts company that scam foreclosed homeowners out of business. So this is the one where they're basically, people are finding, let's see, well, let's read this one. Actually, can you read that from here, Alice?
Which one?
This one, you want to read this?
In the consent decree filed today, REIN is legally required to stop its deceptive scheme. The key players in Ryan's scheme are prohibited from engaging in similar conduct in the future. Ryan is also required to pay $50,000 in attorney's costs and fees and $35,000 in penalties, $27,500 of which is suspended as long as the company does not violate the terms of the consent decree. In the course of its scheme, Ryan approached 35 consumers. He had signed contracts with 16 of those consumers. Ferguson sought and received an injunction before Ryan could collect on its unlawful contracts. On May 30, 2018, a judge ordered the company to halt its deceptive practices while the state lawsuit progressed. This blocked the company from collecting surplus funds from Washington homeowners. Should I keep going?
Sure.
This company preyed on people facing foreclosure. Ferguson said, foreclosure is stressful enough without scammers taking money rightfully owed to homeowners. My office will continue to be a watchdog for these consumers. Of course, he's now governor. In May 2018, Ferguson filed a lawsuit in King County Superior Court against Ryan, asserting it charged excessive fees, often more than 50% of the surplus funds homeowners were entitled to following the foreclosure of their home, much more than the 5% allowed under Washington law. Harry Henningsen, Daniel Stack, and William Gastineau, who all played key roles in Ryan's scheme, are now also named as defendants in the case.
Wow.
All costs and fees will go toward further enforcement of the Consumer Protection Act. With the real estate market booming, more and more foreclosure sales bring in more money than is owed on the mortgage. These additional funds are called surplus funds. Any surplus funds are deposited with the county superior court. Homeowners can recover the surplus funds through a relatively simple process that most consumers can handle themselves or with minimal assistance from an attorney. Ryan approached foreclosed homeowners soon after the foreclosure sale before they received notice that surplus funds are available. Ryan told consumers that surplus funds may be available, but that action must be taken quickly or they may not be able to recover them all. Hallmark of scams.
Yeah.
According to the lawsuit, the company violated the Consumer Protection Act when it deceived homeowners with high-pressure sales pitch that created a false sense of urgency and misrepresented the process for recovering surplus funds. Ryan's sales tactics included repeated calls and visits to the homeowner, talking to neighbors, and in at least one instance, approaching the 9-year-old child of a foreclosed homeowner as she got off the school bus.
Jeez. What scumbags.
In one example, Ryan told a Buckley farmer his family was entitled to $44,000 from the foreclosure sale of his parents' home. The company didn't tell him that the sale made more than $134,000 in surplus funds. We were getting scammed, he told a King 5 reporter.
Okay.
So scum of the earth, apparently.
Terrible, right? So and there's these people that, they find out that people are in desperate need of help. And instead of the help, they're the sharks and they're preying on them. That's terrible. So that's good that they went after them. Let's look at the 5th one, and this happened just last year. Velasquez
Regarding labor.
Framing LLC and Cascadia Homes Inc. I've heard of Cascadia Homes.
I heard Jasper too.
The Washington Supreme Court ruled that pre-lien notice is not required for labor liens under chapter 64 RCW. This decision clarified the rights of subcontractors in securing payment for their labor. Ah. So that one's kind of unique. Number 6, Alexandria Real Estate Equities Inc. versus University of Washington, 2023. This case involved the University of Washington selection process for a real estate developer. The Court of Appeals examined the legality of the university's ground lease arrangements and their compliance with public institution regulations. That's a co-counsel one.
I'm kind of glad to see that these aren't involving brokers.
Yeah. Landlords and Yardy Systems price fixing lawsuit. 2024, U.S. District Judge in Seattle ruled that a lawsuit accusing property management companies and Yardy Systems of price fixing could proceed. The plaintiffs alleged that the defendants overcharged renters by using software tools to share non-public data and to coordinate rental prices, violating antitrust laws.
That would be like brokers having a back-end private, let's say Facebook page where they were coordinating
Yeah.
and setting commissions. The exact equivalent of that.
But for rentals. Oh, wow. 10 property management companies and a software maker they use managed revenue have lost their bid to dismiss a lawsuit accusing them of overcharging millions of Americans renters living in multifamily housing. Wow. Yeah, I didn't even hear about this one. Proposed class action filed last year alleged a group of owners and operators of multifamily residential properties were violating US antitrust law by coordinating on rental prices. The lawsuit accused the landlords of using Yardi's revenue management tools. I've heard of Yardi's. And to share sensitive, non-public data in order to fix rents and maximize profit.
Mhm.
California-based company does not use confidential pricing figures to generate rent recommendations, but instead relies on publicly available housing market information and its clients' own data. So there's nothing illegal about Yardi's revenue management product, and the alleged allegations against the company are simply false, Yardi said. The lawsuit is part of a wave of new cases in recent years accusing companies of relying on revenue platforms and computer algorithms to coordinate illegally on pricing rather than making individualized business decisions.
Well, think about what's going on right now with, was it Compass or
Yeah.
Redfin or Redfin by Compass and,
Compass,
right? And then, Rocket. I mean, it's like they're trying to do end to end,
Yeah.
right? How isn't that gonna affect pricing in the market? Not to mention eliminating us.
the government's gonna have to keep eyes on that type of stuff. They'll have to.
Those are
Because-
big.
Because if they
Yeah.
keep gobbling up everyone, and then it's gonna become a monopoly. There won't be the competition.
Right.
And yeah, I mean, we can talk all day about the CCP and the Compass battle, and there's a whole bunch of stuff brewing right now, and it'll be interesting to see what happens. And we'll talk about it at the sales meeting this month,
They
for
might get
sure.
rid of
It's gonna come up.
Can you give us a quick summary of what Compass is doing?
Super duper long story short,
Okay, this,
they wanna make it okay to have their own private MLS for just their own Compass brokers
oh,
for
interesting.
coming soon properties only.
Right.
So it's pocket listings.
Okay.
That's
That's
what they
I-
want
But on a huge
And if-
scale.
yeah,
on a massive scale.
Yeah.
And then Northwest MLS is like, no, that's against the rules. You're a member of this privately owned, broker owned, MLS, multiple listing service, which we do not allow that.
You can look,
because
they
we
just released a
believe-
bulletin on it.
Yeah, it's getting to become a bee's nest. Now
Look on
Compass is
Instagram, too,
doing
like
a class action lawsuit against the Northwest MLS. They've launched a website to go to basically tell the public, come here if you've ever sold a home in Washington State, and if you used a Compass broker. So now they're looking at doing a class action lawsuit.
Oh, because Northwest Multiple Listing Service has been so cool about everything, I thought.
They are,
They are.
They are.
compared to especially other
Yeah.
MLS.
So, I mean, really, we could we could get really deep in the weeds on this one for sure, and I'm definitely, I think CCP is important, but I also at the same time believe a seller should have a right to make decisions about certain, things. As far as like getting it on the market or in a way to test pricing, especially in the luxury.
Mhm.
I could see it being a huge benefit to sellers, so I understand that, but man. If that's the rules of your MLS, that's the rules.
Yeah.
It's hard to, say what happens with that, if the
Perfect.
MLS will end up booting Compass out. I don't know if that could even happen.
That'd be a big.
That would be, yeah, they would be out of the MLS. I mean,
Wow.
when only less than 6% of properties that do go through these types of systems even sell off market. That's it. So it's a very low percentage
Boy,
anyway. But it's a huge thing to tout, to make your home, to be loud in an industry, and some brokers who also believe with that they'll look, well, hey, our CEO is. He's even fighting the MLS. I want to be with this company, but it's a double-edged sword.
I mean, in the end, it could create two side-by-side MLS.
Well, if they get their way, I promise, because what will happen? Every single big company is going to do the exact same thing.
Right.
And who is that gonna crush? and hurt?
The buyer
It's gonna hurt buyers?
is going
And-
to create discrimination. It's going to it's just going to create, and lawsuits are going to happen.
Yeah, it'll cause a huge.
Like we haven't learned from the beginning.
I know, you're so right. It's like, this is the way the MLSs used to be.
Right,
And they're like, this doesn't work.
back to.
It's, so, yeah, we'll keep talking about that
Okay,
one when it
thank you.
comes up, but that's the
Agreed, agreed.
overview. Yeah. Okay, next one, number 8 is Zillow shareholder class certification appeal in 2024. The 9th U.S. Circuit Court of Appeals reviewed a lower court ruling that certified a shareholder class alleging Zillow misled them about its house flipping business. You guys remember this one? The outcome could impact the criteria for class certification in securities litigation. So this one was when Zillow, Redfin, everyone was doing the, hey, we got buyers, you know, like we'll buy your home for market price. This is what there's, well, no, first they didn't say that. First, like, we'll buy your home. We will, basically fix it up and sell it, and then you'll get paid out. You can, go on, buy your new home, and we'll take care of everything. No one has to come through your home. We have iBuyers. You remember that? Who's an iBuyer?
It's the flippers, right? Like,
It was described as investment buyers, flippers. WeBuyUglyHomes.com, they've been around forever. Those are what iBuyers are. It became a thing in, like, get ready for iBuyers. They're coming into our industry. We're like, they've always been here. And everyone was freaking out. I'm like, do you guys
Where
remember
are they
these?
at?
Driving by these everywhere. They'd be the little signs, WeBuyUglyHomes.com. They've been around forever. So that wasn't the part. It was that these giant companies were trying to do it on a grand scale. Well, what happened is when there was competition, Redfin and Zillow, they were like, oh, no, we do things, because people were like, you're ripping homeowners off. You're taking equity. You're doing the same thing. You're skimming equity. And they're like, no, we're buying at market value. And we stand behind that. And so Zillow, Redfin, they both were saying this at the time. And then what happened is what happens when you start buying stuff at market value as a flipper?
Yeah,
you
lose
lose
out.
Yeah, profit.
You can't turn profit. You're gonna end up buying maybe a couple and maybe you barely make anything, or you start running into huge issues on the properties, and then the next thing you know, you're upside down. So now they were losing more and more money. Well, past homeowners were like, you ripped us off. You did not buy our home at market value. You said that you would. Here's what your Zestimate even said about our home. So it was getting close to a class action lawsuit kind of thing again, which, boom, they ended up squashing that program. Like, yeah, this is stupid. Let's, that's what happens when you got Wall Street money behind you, running you. You have to turn profits at a certain point, or you're done, or you're doing what happened. Redfin just sold, right? So let's see. The 9th U.S. Circuit Court of Appeals agreed last month to revisit a Seattle federal judge's decision to certify a class of Zillow shareholders who accused the real estate listing company of lying to them about its now shuttered program of buying, renovating, and reselling houses. The mid-case appeal, if it goes as Zillow hopes, can make it substantially more difficult for investors to win class certification from federal trial judges in California and other states in the Ninth Circuit. So they were trying to stop that, from getting a much more larger, right, legal action.
I mean, my takeaway from this is that, we see a lot of these things coming down the pipe with these big companies trying to make major plays. And I see, there's a check and balance going on, where it isn't always, it seems very ominous.
Yeah.
But all it takes is a lawsuit. you know, an antitrust or consumer protection lawsuit, yeah,
Any of those.
it puts the brakes on it pretty quick.
Mhm. All right, so. Number 9. And this one's newer, so we gotta definitely look at this. The Covenant Homeownership Act legal challenge. So it's coming. Do you remember them saying that, hey, we're gonna have this out there, we don't know how long it's gonna be around, so anyone who has got, you know, we had quite a few people in this office did these loans. And they're insanely good for a buyer. I mean, it is like the huge difference. Aaron Hafner was talking yesterday to another broker and me, and he was explaining how this buyer basically barely qualified for like a $300,000 home. They had a car that they owed, you know, that they were paying $989 a month for, you know, and their mom was gonna gift them some funds to help, you know, basically get in this house. Well, they figured like, hey, if we change things, have the mom help pay off the car, and then we get you into this program. Now, not only would your payment be way less, but you can afford, he hasn't told them this yet, but they could buy a home for like $550. Cause it's that huge of a difference, cause they get the 20% down and closing costs.
And this is specifically for racial and ethnic groups.
Yeah.
Mm.
Yep. So now let's take a look and see. Washington's Covenant the Home Ownership Act, aimed at addressing historical discrimination in real estate covenants, faced legal challenges alleging it discriminates by restricting eligibility to specific racial and ethnic groups. So we'll see what happens. And this one's not settled yet because people are still doing these programs. Let's see. I just want to get to the part about. And it's zero interest for the down payment funds too. It's huge. So far, there's been 247 homes purchased. Distributing a total of 27.5 million since last July per numbers from the State Housing Finance Commission. That averages about $111,000 per loan.
So these are really low cost homes.
Oh, it's huge. These are huge for people. Another 54 loans are waiting to close for a total of 301 loans, either completed or in progress. That's crazy. Out of 301, I bet you our office has about 18 or 19 of them.
Really? Wow.
That's huge. The fine print, buyers can qualify if they are Black, Latino, Indigenous, Pacific Islander, Korean or Asian Indian, or if they have a parent, grandparent, or great grandparent who was. Those groups still have much lower home ownership rates than white Washingtonians.
You know, when my dad came here to Washington, he had the hardest time trying to get a loan.
Oh, I'm sure.
And so his friend, where we bought in our first home on Harrington Avenue, had to buy the home for him to, because he just couldn't.
That's a common story, man. Admit.
And he's well educated, he's well spoken, English flawlessly, you know, isn't.
Okay, so looks like last fall, a lawsuit was filed against the head of the State Housing Finance Commission, Steve Walker, asserting the program as discriminatory because it is open only to certain racial and ethnic groups.
Basically reverse discrimination.
Yeah, well, they knew this was gonna happen. The nonprofit filing the lawsuit, the Foundation Against Intolerance and Racism, says on its website that it is focused on overcoming identity politics. So we'll have to, you know, stay tuned for that one. And I'm sure it's probably a pretty easy one for them to prove that, and they'll probably squash that program, but hopefully they can do some more good with the funds. But some of the stories, you know, that we've heard behind, you know, people who have got these homes, it's just like Amit said. I mean, people would never have been able to ever get a home without this
But
program.
I wonder if there's a way to have a program to help people who are having a hard time getting a loan regardless of their ethnic or, melanin,
Maybe?
and have that program be available.
Yeah.
So it isn't, I just personally, I think basing it on those factors is
Yeah.
not a good thing.
I agree. I mean, we
But
want
helping
fairness
people
for
is-
everyone.
Helping people is.
Yeah, we want fairness for everyone.
I mean, that could be a fight forever though, like, when you go back to like indigenous days, when.
Yeah.
Like, you know what I'm saying, like Native Americans, right, like how far back do you wanna go, what's right, How do you
Yeah.
say what's right and what's not, it's
Hopefully they'll develop the program. I know that the funds where they came from is like from all of these, groups and stuff that were trying to help people to get into homes, especially in the lower to middle class where they wouldn't be able to get in without
We
it.
got a lot of groups that can't
I
get
know.
homes right now.
Yeah.
there's too many, for
Regardless
sure.
of
Yeah.
their identity, they're having a hard time.
Yep.
The
All
theory
right.
behind the program, which is based on a study out of the University of Washington, was based on the denial of intergenerational wealth. If you go look at some of the covenants way back when, people were denied access to live in certain neighborhoods, even back into the 70s.
Oh,
And
yeah.
so it's not that long ago, and it probably should require women because most women were redlined from buying a house. But there's great theory to why they had the program came out.
And that's why
to-
White Center is called White Center.
Yeah, you're right.
All of that may have been wrong, but.
That's how that
Oh, I did
originally.
not know that.
Doing it wrong in the future to.
And it's nothing like that now, whatever, but yeah, they tried, was.
My dad's bar was called the White Spot, and they were pissed when he bought it. I'm not kidding.
Wow,
Yeah, and here in Kent, it was.
yeah,
things were-
racism unfortunately is still alive today.
So
you know?
it is technically better to call it Rat Center then.
All right, number 10, US DOJ, a lawsuit against major landlords in 2025. The Department of Justice filed a lawsuit against major landlords, including Cushman and Wakefield, accusing them of coordinating rental prices using RealPage software. Wow, look at that. It's
It's
another,
commercial,
yeah.
commercial.
This case highlights concerns about potential collusion in rental markets. So
I've used both of those, Yardi and RealPage.
you have,
And they do. You can look up all kinds of different things and, okay, they're charging this much, we're doing this.
But they're saying that from the one before, they're saying the data is public knowledge. And they're just aggregating it and making it available.
I think the reason they're saying it's public knowledge, because if you,
well, aren't those
Subscribe to
sites
their
public
software.
now, but they were membership before? I
have
thought.
to pay for the software,
And,
you still gotta pay.
They're an aggregator.
oh, yeah.
They're taking public data and they're aggregating it. I don't know how you can say that causes collusion.
Yep. All right, so obviously the very, very biggest one that we've dealt with was buyer agency, right? That completely has totally changed our entire industry.
Not just better.
Some things, yes, some things not. So who knows? I'm gonna iron out more. All right, time to dive into our actual forms. 22RA, this is the attorney review addendum to purchase and sale agreement. Use this addendum. This addendum is to be attached to a purchase and sale agreement when the sale is I think that meant is conditioned on the buyer's attorney's review of the agreement, the seller's attorney review of the agreement, or both. Like most Northwest MLS forms, the contingency is waived if notice of termination is not given within the specified time period.
So Eric, does it matter if it's a Washington state attorney or out of state attorney?
No, it doesn't. No, does not matter. Nope, there is only one. I thought that's. I guess it does not say. I thought it would give attorney. No discrimination. Oh, here's our new form that just came out today. We've got, and
Homeowners insurance is unavailable.
They've updated the form. Just today it came out, they've updated the 22 VV, which we've got coming up in the next. That one's coming right here. This one's revised today.
That's good.
Yeah.
It's contingency for a buyer being able to get homeowners insurance. Not only getting it, but at the price that they want to keep it in.
You know, it's interesting, is out in the Spokane market, it's included in every deal.
Oh, yeah. It's
Every
because
single
of
deal.
fires, right?
Yeah, it's just, and I didn't do a deal in all the years there that didn't have.
Without it.
Mhm.
Yeah, so I just found out this week that Suncadia. Have you guys heard this yet?
No.
A bunch of the insurance companies are dropping everyone in there.
Really.
Wait, why?
Because of
Why? Why would they do that?
worries and fires, right?
Fire.
Fire, baby.
No, but everything.
Yep, it's in a very high risk fire zoned area.
Building so much-
And the multi-million dollar properties, they can't afford to replace them.
So they'll have to do the risk pool insurance through Washington.
Probably.
But they can't get full coverage.
It's insane.
Wow.
So
They'll have to separate the fire insurance from everything else, from my.
Something. All right, so I'm assuming you would just have to do it on a blank notice. You'd have to use a 90 for issuing a termination based on the attorney review contingency. All right, the dates, the buyer's names, the seller's name, the property address. Buyer's attorney review, check the box for buyer's attorney review contingency, insert the number of days for the contingency. And then in seller's attorney review, same thing, check the box for seller's attorney review contingency, insert the number of days for the contingency. Initial and date, buyer and seller should initial and date these blocks at the time the addendum is agreed to, so it is clear that the addendum is part of the purchase and sale agreement. When should you use one of these? When do you think you would want to use one of these?
Maybe an off-market deal.
Yeah, I'm ready.
Heck, yeah. If you, you said it too, both of you are right. Off-market deal. 100% of the time. Unrepresented buyer. Or unrepresented seller on that agreement. If any party is unrepresented,
Seller
Without-
financing.
huh?
Seller financing.
Financing? Yep, another great one. What else?
When you're buying a house, maybe like directly with the seller, like off, I guess
Oh.
off market, but you're the realtor and you're buying it.
And the buyer,
Mm-hmm.
correct? Oh, yeah. Without a shadow of a doubt, and I would have a much longer period of time for them to review.
If it's like in a special part of land, potentially landlocked easements and like things that.
Yeah.
are above,
Why not? Realistically, anything that you think could be, where you feel your gut like, ooh, man, this is a weird deal. Boom, right away, you're like, I'm gonna just add this in there. Or buyer's buying it and he's like, yeah, I've checked with the city, it's vacant land, and I think I can build like 20 homes on this lot, on this land. I don't need a feasibility study. I'm ready.
I had one that was waterfront and the utility company owned the, 25 feet of the
Oh.
core. And, they were representing that you could actually build a dock and, so, yeah, we had to get it.
Any of those. Cal?
How do you think that would affect, so I've got somebody who has to sell their house, they need to use funds quickly. They say sell it 50,000, 100,000 below market. Would you, how does?
And
just
the
to get rid of
person?
it.
Is it someone you
No.
know?
No, you don't know them.
Oh.
Just you have a seller that says, I need. to
And
get
this is
money
vacant
quickly."
land?
No, house.
Okay.
So I need to get money quickly because I have to pay for my, to get into somewhere. Is that something?
I would include it because why, I mean, when people wanna sell stuff fast, that's all, and they need money, that's a red flag. That's always a red flag, especially like if you get that with vacant land, we've had a lot of scams. Because vacant land, you never have to meet the person, they could be contacting you, maybe an office online lead. It could be through Zillow lead, someone contacts you through homes.com or realtor.com is another one that they like to use. Websites to find people. They're like, yeah, I want you to help sell my land. Here's the parcel number. I need to sell this quick. As soon as you're in dealing with that, it's not good. So you want to use this like whenever you think you need to use it, just add it in. If you're using transaction desk and you're writing off-market deals, like Form 47, a seller represented buyer, off-market, to an unidentified buyer, Form 47, like it's already included in transaction forms pack. I've included it in both of the for sale by owner, one where you're representing a buyer and the seller's unrepresented, or maybe they got representation, doesn't matter. Have it in there. All right, let's jump over to the next one. Automatic extension of closing to accommodate Regulation Z. So this is the 22 Reg Z. Reg Z is a part of the Truth in Lending Act, which is, something that all buyers, are going to be utilizing when they're getting a loan, right? That this is part of the rules to lending. So use this form when buyer is financing the purchase of the property, but the purchase and sale agreement is not contingent on buyer obtaining financing. In other words, use this form when buyer is getting a loan, but the agreement does not include a financing addendum. So if you have 22A, you would never use 22 Reg Z because Reg Z is already on the financing contingency on 22A. It's already built into that form. This is like one of those deals where maybe you're writing it up and they're fully underwritten, approved. They're getting a loan. You've identified that on maybe on 22EF, right? Evidence of funds addendum. Evidence of funds addendum does not have Reg Z on it. And therefore it would never protect a client in the event that they're towards the end of, getting ready to close. And there's a mistake on, a quarter point of the annual percentage rate that the lender has issued to them in their good faith estimate, or what used to be called the good faith estimate, right? So the closing disclosures, it's all about that. Buyer obtaining a loan. This form contains a representation from buyer that buyer is obtaining a loan to purchase the property. Regulation Z, effective August 1st, 2015. Regulation Z of the Truth in Lending Act, TILA, 12 CFR 1026 requires that the lender provide buyer with a new closing disclosure at least 3 days before closing under the following circumstances: a change in the annual percentage rate, or APR, of buyer's loan or loans by 0.25% or more for a fixed rate loan, or is that
180.
1.8? Yeah, or more for an adjustable rate loan. Ugh. A change in the loan product, right? So they change the loan product, or the addition of a prepayment penalty. So it's to protect consumers with loans. This means
1/8%, that's not much at all.
right, but it's a big deal to their payment. This means that buyer may not be able to timely close a transaction. D, extension of closing. This form is an addendum to the purchase and sale agreement. In the form, the parties agree to extend closing for up to 4 days as necessary to accommodate the requirements of Regulation Z. Why would they update this? Why is this protection even around?
I don't want the seller to have a way to get out of the deal if, the CD is off, right? There's no fault of the buyer.
Right, it's not a fault to the buyer. They don't want the seller to be able to just sell to someone else and like, oh, hey, this happened. It's not their fault.
Yeah, this is an automatic agreement to extend.
Automatic extension. This doesn't happen very often, but I've actually already seen one this year. So why would they implement this? Two, what else? What else do we think the reason it would be to say we need this type of a rule?
Radical like change in interest rates, I don't know.
Well, we gotta go back in the past to see what was happening. Those of you that have been in the industry in the 2007, crash of the real estate market,
Just give them the only.
because of basically fraud happening with lenders and issuing loans. They basically came up with this rule because what was actually happening. And I remember this happening all the time. The buyer would go to the lender says, yep, your interest rate is 6.5. You got a great rate. And they're like, okay, good. And here's your payment. They would get to the closing table on closing. And they would get there, and all of a sudden they're signing docs, and the person signing, they go, yep, here's your rate, it's 7.5. And your payment is this. And they're like, what? Hey, this is a mistake. The lender, wait a minute. And they call the lender, and the lender's like, oh yeah, sorry, the rate went up. You're doing a stated loan. So, unfortunately, the cost when they were selling this to the mortgage company, they wouldn't get it at this rate. So this is the new rate. Sorry, if you don't buy the house, someone else will. This is what lenders were telling clients. Literally, one of my clients was told the exact wording. And they bought it. And they bought it anyway. And then they ended up having to short sale like 3 years later. Because the prices of, all the homes were upside down. So they had to come together and basically make a rule that you can't, if you're getting a mortgage, they have to follow the regulations, the guidelines. You cannot be, doing this type of practice on the consumer. So that's why this whole thing is in place. So in the event that the rate changes an eighth or a quarter point, then they've got to redisclose. And there is an automatic extension for up to 4 days. For business days. 5 days or less, weekends and holidays don't count. So you got 4 business days so that they have proper time to redisclose. All right, questions, you guys? Anybody? Wasn't too bad today. Hopefully it didn't scare anyone too bad. We didn't get too many of the broker laws.
Off topic of that,
Yeah,
there's supposedly the new budget they're coming out with is gonna raise taxes on properties.
talking about it.
And how do you think that's gonna affect you'll have people not buying essentially.
Ferguson says he won't sign it,
Yeah, he already said he'd veto it, right?
Yeah.
He's
So
already
they-
stated.
so they'd have to overcome that veto.
Yeah, we'll see. Our state's getting pretty high for the taxes. It's not California level, but we're catching up.
Yeah.
It's getting there.
We're catching up. All right, you guys, thank you for making today. We will see you on the next one. Take care.